I'll move straight on to Tim Graham. Tim works for obviously HWL Ebsworth, and thanks so much for letting us use your boardroom facilities. I think they're the second largest firm in Australia. Tim was admitted to practice in 1998 and practices exclusively in the areas of strata and subdivision law, owners corporations, building and construction, planning and property law. One of Australia's foremost strata lawyers, Tim's been awarded a fellowship at the Australian College of Community Association Lawyers for his expertise and regard by his peers as a specialist in strata, subdivision and owners corporations. Tim represents OCs of all sizes. His clients include many of Melbourne's largest and most iconic buildings, broad acre developments and gated communities. He has extensive experience in domestic and commercial construction law matters, providing contractual advice and appearing in building defects claims, insurance reviews, repair and maintenance cases at VCAT and the courts. Tim also appears in planning appeals. He's a regular presenter on owners, corporations and subdivision law topics. He's conducted over 150 seminars for a range of professional associations, management bodies and financial institutions, including the Australian College of Community Association Lawyers, Strata Community Australia Victoria and the Real Estate Institute of Victoria. Tim writes prolifically for the periodic publications of many industry associations and management companies and franchises. He's published regularly in the Australian Property Law Bulletin and is a member of the Bulletin's editorial panel. He's authored the inaugural Owners Corporation chapter of the Lawyers Practice Manual and writes the case studies update of the loose leaf publication Subdivisions with the Lot. Tim's accepted an appointment as a guest lecturer at RMIT and he's going to chat to us about committees. Thanks so much, Tim.
Michael, thank you. Yeah, that needs to be truncated, doesn't it? So it's always good to hear James speak. He's an excellent presenter. I must beg to differ on one point though. Of course, $220,000 for a $2,000 plot of carpet is eminently reasonable. I don't know if you made that clear, mate, but it was interesting also to hear what James said about those legal cases, that Pebble Beach and the window locks. I won't compete with James, but I'd like to start off by saying that some of the sort of more oddball complaints and legal proceedings that arise in owners corporations, these won't be, or some of them, completely unfamiliar or foreign to you, but I created a bit of a list. A complaint against a manager for failing to ensure that an owner was nominated on the committee, so of course that's the manager's fault. This fellow, blocked down in Seaford, near the beach, he flies around Australia and a little bit internationally for his work. He's an engineer, and what he likes to do is he set up a couple of CCTV cameras on common property. So he likes to sit in the airport lounge and monitor what's going on in regards to the vehicle flow on common property and car parking, and dish off a complaint every time he sees something he doesn't like. He made a complaint again. He likes to go after the manager, this bloke, but there was a shrub. It was about 60 centimetres high and it was dead. And he made a complaint to council on the basis that constituted a fire risk. Made a complaint against a 12-year-old boy who was riding a scooter, apparently on common property and allegedly in breach of the rules. I don't know. One of the most perfunctory ones, of course, was crap being detected on common property. That was a complaint against the manager, as was someone throwing a kebab into his fish pond. It's all the same person. And he got up to about 150 complaints in about 4 or 5 months. After one of the things went to VCAT, he got thrown out, and the Owners Corporation sought to enforce a cost order against this bloke. He responded by seeking orders that VCAT incarcerate the manager for 6 months for pursuing him for a lawful cost order. He's one of my favourites, but I think that the best proceeding I've seen, I went to VCAT. We didn't act in that matter. My associate solicitor was actually down there, and it's a case that came on before his case. And an owner within an owners corporation had sued another owner within an owners corporation, and the alleged breach was that respondent owner had failed to walk in a straight line on common property, and he got sued for that. So this is what happens. We'll say a bit more later on about what a committee's role is in regards to enforcing rules, but suffice to say there is an element of quality control in screening the merit of complaints. Committees are an interesting species in Victoria. In fact, it's fair to say that in the 25 years or so since the Subdivision Act passed, committees have really suffered an identity crisis. And just on that point, when I talk about the Subdivision Act, so it passed in 88, it came into operation in 89. And we had two sets of regulations under the Subdivision Act in 89 and 2001. And ultimately, we get the Owners Corporations Act in 2006. But distinguish yourselves by not referring to Michael or Quantum as your strata manager and me as a strata lawyer. That's true if your property was built between 1967 and 1988, then we had strata titles. Since 1988, we've had subdivisions. We hear in the vernacular all this bland reference to strata, and sometimes it's true if the property's in that 20-year catchment starting in the late 60s, but since 1988 we're subdivision managers or owners corporation managers, subdivision lawyers. We're not strata, this and that. Other states have it, sure, but people get that wrong. It really irks me. So let's distinguish ourselves by getting that right. But in any event, the relevance, so since Subdivision Act, we get that in 88, in 89 we get its first set of regulations. And what they said was that a committee could be delegated power. That's pretty straightforward. A committee was recognised as a separate legal entity, an independent entity in the same way as a natural person or a company, and it was given power. So it could go and it could get things done and everything functioned perfectly. When we got a new set of regulations in 2001, unfortunately the language changed, and what they said was that an owners corporation can delegate power to a member or officer. Now, a member is an owner and an officer is probably an executive member, possibly an appointed manager, for example. But what we didn't get in 2001 was this notion of a committee being a separate legal entity. So the OC actually couldn't delegate power to a committee. What would happen, of course, is at AGMs committees would be elected, and insofar as those committees were comprised of members or officers of the owners corporation, then that's okay. Delegation could occur and things could get done, but it was actually delegation to individuals, not the committee as an independent, separate legal entity. And of course, there's one class of persons that weren't recognised as being capable of accepting a delegation from the owners corporation under the 01 regs, and that was proxies. So if you're a proxy for an owner and that owner nominates you to represent them on the committee, well, you can go on the committee meetings, there was nothing unlawful about that. The reality was that the owners corporation did not have the power to delegate power to an individual who was a proxy. So it was, that's how it worked, and it was an untenable situation. It all became much clearer, purportedly, in 2006. So the Owners Corporations Act passed, it comes into operation on the last day of 2007. And what that said in about section 101 was that a committee has all the powers that may be delegated to it by the Owners Corporation. Committee has all the powers that may be delegated to it by the Owners Corporation. Now, that seems to say, and trust me when I say that in the review process that went for a number of years leading up with exposure drafts of the bill and issues papers being released, it was always intended, as we had in 1989 up to 2001, to have the committee as a separate entity capable of making decisions. And then we lost it in 2001 until the Owners Corporations Act became operational. What was intended in all of the material, it seems quite plain, was that the statute was supposed to confer upon the committee the ability to make decisions. And that's the language it used. The committee has all the powers that may be delegated. So you look at that and you say, well, has all the powers means it's invested of them, it has them. The statute has given them there. It's an immediate possessory word, and the committee's invested with the power. And powers that may be delegated, well, they're powers exercisable by an ordinary resolution, because committees can't, never have had, and never will have the ability to make decisions requiring a higher threshold, special resolution, for example, the conferment of a lease or the passing of rules, or a unanimous resolution such as changing the plan of subdivision. So committees can't have those. So we looked at section 101 and said, that says that a committee is given, it has the powers, it's given the powers, exercisable by ordinary resolution, in other words. Now, the alternative reading of section 101 was that a committee has all the powers that may be delegated, and we emphasise the word may, and we substitute that perhaps with that actually are. So a committee has all the powers that actually are delegated. It was capable of two meanings. We had this ambivalence on the part of both VCAT and the legislature. No one knew what was going on because in the middle of 2009, a committee terminates its manager in a case called Network Pacific and O'Rourke. And the manager says that that termination wasn't effective because the committee doesn't have any power, because there's been no resolution to delegate the power and no execution of an instrument of delegation of power. So I haven't been terminated because the committee was effectively a shell. VCAT agreed. VCAT said that that a committee power can be delegated to the committee. Section 101 doesn't automatically confer it. You actually need a decision by the owners' corporation to confer that power, and it should be evidenced by a signed instrument. So that's July 09. In December 09, or November, December 09, we get Martin's case, which decides the diametrical opposite. In that case, Mr Sykes had a shell that he wished to develop, and part of his proposed development was removal of a corrugated iron roof and replacement with some other element. And that required the owners' corporation's permission pursuant to the rules. Mr Sykes sought that permission and it wasn't given. The next AGM come round, Sykes had done whatever lobbying and campaigning he felt appropriate to get himself on the committee and probably some friendly people. And the request came back on the agenda, and this time a different decision was made because of that campaigning, and Sykes's works were approved and he had a planning permit and he was poised to go. Until Mr Martin said, who had been a committee member, I think still was a committee member, but he got outvoted. He applied to VCAT. He probably became aware of the O'Rourke case and said, well, this owners corporation hasn't resolved to delegate power to the committee and hasn't executed an instrument of delegation. So the committee's purported approval of these works by Sykes can't be acted on because there's no power to give that approval. And VCAT disagreed. VCAT said you don't need a resolution, you don't need an instrument. The Act, section 101.1, automatically gives it. The committee has the power. So we get polarised decision out of the same tribunal 4 or 5 months apart. And if that wasn't bad enough, so we're up to about November, December 09 now, early 10, we get Luino's case, 19 block of units out East Boronia. And Luino, there's no spectacular facts behind that particular case. Luino, no doubt aware of those polarised decisions that have been made, applies to VCAT for an order or a declaration that this owners corporation can't, or probably more generally, if I remember correctly, that do you need an instrument of power or a resolution, or is it automatically given by the statute? And the tribunal said it was the former. So we've got O'Rourke says you need a delegation, Martin says you don't, Luino says you do, and those cases 6-7 months apart. So no one knows what's going on. In 2010 it releases the Consumer Affairs Legislation Amendment Act or the like. And what that says, now we've had an amendment to section 11 which I think has clarified it, but it's really quite a bizarre scenario. Section 11 subsection 2 says that an owners corporation can delegate by resolution or instrument powers to a whole range of people, including the committee. Section 11.5 says that if no delegation is made under 11.2, then a committee automatically is given all powers exercisable by ordinary resolution. So what we've effectively got is a default statutory position where the committee has power to make decisions exercisable by a simple majority. And if indeed the owners corporation delegates power to the committee, it's actually a negative delegation. It's actually withdrawing power from the committee. So I think the general practice is unless, or should be, that unless you want to restrict a committee's power to make decisions in regards to a certain thing, then you don't do a delegation at all. You just let the statute do its work. Sometimes with some properties, smaller ones, I think, probably more likely than larger ones, it may be appropriate to limit the committee's ability to, for example, enter into contracts or to terminate contracts or to exceed expenditure by a given threshold amount. I think the larger the owner's corporation, the less likely those controls need to be in place. And I just might make this final point in regards to if you were looking at delegating power through a resolution or an instrument, to me that's a bit of a misnomer. Resolution's fine, so we resolve to delegate all powers to the committee exercisable ordinarily, that's okay. You should then sign an instrument as evidence of that resolution having been made. So the best practice if you're going to do any delegations is to do both, get the resolution and get the instrument signed. I don't think you can have an instrument signed, and the legislation gives you an alternative, resolution or instrument, but how can you sign an instrument without the resolution having been made? It just doesn't make sense. So the Owners Corp hasn't made a decision to delegate power, yet someone signed this document saying power is delegated, but it's a document in the air or built on sand or whatever other colloquialism you wish to use. Unless a decision is actually made, then the document can't sort of exist in a vacuum. As far as functions and powers go, the Owners Corporations Act says nothing about what a committee's functions and powers are. It doesn't give you any. Presuming you must have some, and let's presume moving forward that the committee, that we haven't limited, the OC hasn't limited committee power, that there's no delegation withdrawing any power from you. So we're going to presume moving forward in this paper that you're not limited in your ability to make decisions in regards to certain things. So what are the powers and functions? Well, the Act doesn't talk about those, but what they must be is the powers and functions of the Owners Corporation, because you're its delegate. So when you go to Part 5 of the Owners Corporations Act and you open up and it says, okay, what are a committee's powers and functions? And it's silent. So what in the name of Hades is our role and responsibility? Well, to me, I think you go back to sections 4 and 6 and they set out what the Owners Corporation's functions and powers are. And as a delegate, a statutory delegate of the Owners Corporation, then you have the same powers and functions, with a couple of limits in terms of special resolutions and unanimous resolutions. But by and large, your powers and functions are the powers and functions of the Owners Corporation. And that makes sense. You're a delegate, and they can't go beyond the Owners Corporation because that would be like a river rising above its source. You can't. The Owners Corporation's here. What you are as a committee is the Owners Corporation between general meetings. That's what the role is. So that's functions and powers. Duties are something else altogether. Duties, we probably know, everyone that goes on a committee, I'm sure, diligently reads section 117 of the Act that says we'll act honestly and in good faith, we'll use due care and diligence, and we won't make improper use of our position to benefit financially or otherwise, directly or indirectly, ourselves or any other person. Those are the duties. Now, provided that we properly discharge those duties, a committee has an immunity under section 118. And it says that provided that you've acted in accordance with your powers or in the reasonable belief that you are exercising or a committee was exercising its powers, then 118 gives an immunity to the committee. Doesn't give an immunity to the Owners Corporation. In other words, you can stuff up all you like as long as you're doing it within the bastion of your power or in the reasonable belief that you've got the power to do what you're doing, and you won't be personally liable. The OC still might be, but you won't be. So in a case concerning 585 Latrobe Street, just up the road here, I can only say so much about it. It's a current case on foot. We had a mediation last week. In that case, there's a hotel operation which is or a related company to the developer of that site. It's a Chinese company. They developed the site, they put in a hotel, and it operated for some time exclusively and solely as a hotel. As years have gone by, then certain owners have opted out of re-entering into leases with a hotel operation, and some people are owner-occupying, some are going it alone in terms of letting out their rooms. And there's a couple of agreements, so we've now got hybrid. There's a hotel operation, and there's some owner-occupiers, and there's some other stuff. Back in 2001, in that building, the Owners Corporation signed an agreement in favour of the hotel operator to do various building management and superintendency tasks. Significant amount, a few $100,000 a year. That becomes contentious, which leads in 2008 to an agreement which almost sets off the 2001 agreement. And what that says is that the hotel will pay 30% of the Owners Corporation fees in consideration for its occupation of common property. As an owner of some lots, it can reasonably use and enjoy common property in the same way as any other owner. But the thing with hotel operations is increased pedestrian traffic, increased vehicular traffic in the car park below. You've got luggage getting banged into walls and scraping on carpets. You've got linen trolleys, luggage trolleys and what have you. So there is an increased wear and tear on buildings, and the Owners Corporation's position in that is the 2008 agreement offset the 2001 agreement. They almost cancelled each other out, and that the 2008 agreement was sound because it represented the existence of a hotel which was increasing the wear and tear. What the hotel then does late last year is get its proxies to form a committee majority, and it votes to terminate the 2008 agreement. So a committee meeting was called. It was called lawfully. A resolution was made. About a month later, a document called Terms of Settlement was entered into. It was signed by Dr. Go and Dr. Go, who are a husband and wife, both who are directors of the hotel operator. And on behalf of the Owners Corporation, it was signed by Dr. Go and Dr. Go, both of who are owners. So the same people have signed the document on both sides of the ledger, and what that document does effectively is divest the Owners Corporation of a couple of $100,000 a year income. The Terms of Settlement also provide for a refund of all monies ever paid pursuant to that 2008 agreement, exceeding $500,000, and various other things. That is not making proper use of your position as a committee member. Committee meetings, very briefly, I don't think there's too much magic to committee meetings. Just make sure that you comply with sections 108 and 109. The administrative task is probably done by your manager, but committee members should know what's going on. 108 sets out a whole suite of people that are competent to call committee meetings. It's almost everybody, but it's not just an owner. 109 sets out a couple of things. The meeting has to be called on 3 business days' notice. The Act originally said 3 days' notice. So if anyone hasn't updated their Owners Corps Act, you might miss that. It's got to be 3 business days' notice. Committee ballots are a odd one. I know that committees often communicate by email, and if all committee members responded to a given agenda point by email, I'm tentatively comfortable with that because we've got unanimity. Everyone's seen the email, contributed to the decision, whatever that certain thing is that's done. As long as every committee member has participated, then you're probably not at too much risk. But the reality is that decisions are made formally, either at a lawfully convened meeting on 3 business days' notice with an agenda that attaches the minutes of the previous meeting, etc., or by ballot. Now, the committee ballot provision is an unwieldy one because what it requires is for a ballot to remain open for 14 days, which is the same time as a ballot of the whole Owners Corporation. And the point about committees operating between general meetings as the Owners Corporation is so that things can get done more quickly without having to mobilise 200 and 400 and 800 lot owners. So the philosophical need for a ballot to remain open for 14 days, to me, is difficult to fathom. It's far easier to call a meeting on 3 business days' notice, and you can give proxies or you can attend by telephone. So it seems to me that committee ballots will rarely be used. I am often asked, well, okay, what if everyone responds within 3 days? Surely, once we've got a response from everybody, that means, well, the ballot can then close because there's nothing to happen for the next 12 days. Well, that's not right. Because what that ignores is that someone might want to change their mind. The legislation says the ballot must remain open for 14 days. It must. I made the point, so we've spoken about the formality of committee meetings, the formality of ballots. That is primary. Now, for low-level items of business, I did make the point, in a practical world, tentatively comfortable with things being done by email, but it would only be the very low-level stuff, because if it's anything that's at all contentious, that some owner out of 1 out of 800 people might want to challenge, and there'll be one. If they do challenge it, if you're relying on some informal email communications rather than a meeting called in accordance with 108 and 109, or a ballot convened under 111 and open for 14 days, the decision is susceptible to being set aside. Minutes, whoever keeps the minutes, just bear in mind, minutes do not need and should not purport to record every aspect of the discussion and every person's subjective opinion about every nuance of each agenda item. It's appropriate that they're descriptive enough, but fundamentally, all minutes have to do is record decisions made. So they don't need to say that John said this and Dale said this and Michael said this and Tim disagreed with them all on this basis, and they're about that long. They just need to record the decision made. It's not scandalous if they record fundamentals of the discussion, but they don't have to. They just have to record decisions. So less is more in certain respects. And I'd just like to adopt and wholeheartedly agree with what James said about committee retention. It's not a one-year gig. Owners' corporations function best when committees function best, and committees function best with retention of the same people as far as practicable. Not many things can be done for the overall benefit and furtherance of a development that can be sort of in and out in 1 year and it's over and it's done and it's forgotten. Excuse me. It's a much longer role than that. So well done and congratulations for sticking your hands up as committee members, and I agree with James that in terms of, well, James is making the point that we should, as far as practicable, select who we want to appoint on committees. I agree with that, and augment the point by saying retention, and don't look at it as a 1 year, but as a 3 and a 5 and an 8 year position is the way that things operate best. Don't know if you knew you were getting yourselves into that, but that's a good idea. I want to say this as quickly as possible about subcommittees. There's only one point I want to make about subcommittees. I understand from discussions with Michael that he advises against them. That's a good idea, or insofar as they might exist, their role necessarily must be one of investigation and reporting back to the General Committee, which in turn at each AGM reports its activities to the Owners Corporation. And there's a legislative basis for that. I'll throw a whole lot of sections at, well, I won't, but I'll tell you that there is a suite of sections that deal with committees, and then when we've got our section that deals with subcommittees, it says that all of those sections that apply to committees also apply to subcommittees, as if the subcommittee was a committee, but for one, which is section 113. And what 113 says is that a decision of the committee is a decision of the Owners Corporation. So a committee decision has the status of a decision of the Owners Corporation. That's good. A subcommittee looks very much like a committee, but 113 doesn't apply to it. In other words, the decision of a subcommittee is not a decision of the Owners Corporation. So what that must mean is, and it's the proper way to practice in any event, committees are elected, subcommittees are not. They don't have the mandate of an election at a general meeting, etc. There's a whole range of reasons why it's proper, and the legislation, by the omission of 113 applying to subcommittees, makes it clear, in my opinion, that subcommittees cannot make binding decisions. They're not given the power under the Act to do so. They might be a useful tool to investigate possibilities of what you want your paving to look like, or how thick the blue racing stripe should be. They can investigate that, and they can talk to contractors, and they can get prices and what have you, and they can work with Quantum in doing that, but they can't make the decision. They don't have the power to. Last thing, briefly, how we go for time, Michael? Yep, good, thank you. Rules. A committee, for a couple of reasons, has a very significant role to play in terms of the enforcement of owners corporation rules. The two fundamental bases, I think, immediately are these. Section 18(1) of the Act says that an owners corporation can't bring legal proceedings unless it's got a special resolution to do so. Section 18(2) says that a special resolution is not required for enforcement of rules or recovery of outstanding fees. It meaning that a special resolution is not required for fees or rules. The committee has the delegated power to decide everything other than things exercised by a special unanimous resolution. So a committee really is the entity that decides how to enforce or how to action an alleged rule breach. It doesn't go to the owners corporation, doesn't need to. The committee decides it. The other point to be made in about section 153, subsection 3 or 4, is that an owners corporation cannot take action in respect of an alleged breach of the rules unless it believes on reasonable grounds that a breach has occurred. So that puts a positive obligation on the owners corporation to quality control complaints. So we're not likely to do too much about the kebab in the fish pond or the ambiguous crap on common property. The committee must control it, and the committee must be satisfied in reporting back to the owners corporation if it's going to take some action in respect of some alleged breach. It's got to be satisfied on balance. It's not law and order, it's not beyond reasonable doubt, but on balance that there is some reasonable ground to this allegation. That is a committee's role. Now, I'll say this about enforcement of rules generally. There is no absolute requirement to enforce rules in this state. If a breach of the rules is alleged to have occurred, well, the committee gets together and it discusses it and calls a grievance meeting and it considers whether or not there's any reasonable grounds to this allegation. That's the role. Once that's done, the owners corporation through its committee has a couple of alternatives. It can either apply to VCAT, it can give a breach notice under 155, and if it's not rectified, a final breach notice under 157. If it's not rectified, they're both 28-day notices. If nothing happens after that, 2 notice procedure, then we can go to VCAT, which poses the question why we ever bother with 2 notices when you can go straight there. But they're alternatives, and the third alternative is to do nothing. And if we do nothing, our role is to advise the applicant or the complainant while we're doing nothing. The usual answer will be because we're not satisfied on what you've given us, a breach has occurred. We don't believe on reasonable grounds as required under 153 subsection 4 that a breach has occurred. Given that we've got alternatives in how to deal with rule breaches, it must necessarily follow. So there's no requirement. We can do different things. It's a discretion. It must necessarily follow that even if we're aware of a rule breach, and even if you might think on balance that that breach has been made out, there is no requirement in this state that you do anything about it. You're given the option to do something about it. You don't have to. If you don't, however, bear in mind 2 things. One is you'll be vilified and castigated for discrimination in the event that you let certain things go through, but you jump on other people for other things. And you could be negligent. For example, if we're aware, if there's a significant trip hazard, and if that's a breach rule, it's not the best example, but stick with me. If that, for example, is breach of a rule, and we're aware of it, and someone's breached the rule, someone's caused that damage. That's the rule breach. Someone has caused damage to common property. In causing that damage, they've breached the rules. But we don't do anything about it. And someone trips and falls. We don't do anything because we don't have to. I've said that. We don't have to. But if we don't, we are susceptible to allegations that we have not acted with honesty and good faith and due care and diligence, and or that the owners corporation is negligent because we haven't done anything about it. So to crystallise that, in the event of a rule breach, we do have a positive responsibility to satisfy ourselves that there's an arguable case, and you shouldn't do anything further unless there, at least on the face of it, is an arguable case, reasonable grounds of a breach. If that's made out, you don't have to do anything in terms of enforcing the rules. You're not required to. But if you don't do anything, you are at risk of allegations of breach of statutory duty, negligence, potentially discrimination. That concludes what I've prepared for this morning. So thank you kindly for your attention on that. We've got time for a question or two? Probably not. I'll be around at the break in any event.
Great.
Thank you. Thanks, Mike.
That's great. Look, Tim will be around afterwards, which is fantastic. I appreciate that. So if you can hold questions till then.